If you're wondering whether you can file bankruptcy without your spouse, you're not alone. Many people are shocked to learn that you can often do so and still protect your household. Imagine wiping out overwhelming debt without dragging your spouse into bankruptcy. For many married couples, that's not just possible, it's actually the smartest strategy. But only if you understand how bankruptcy really works for married people. In this video, I'm going to show you when one spouse can file a loan, when you shouldn't, and how the wrong decision could accidentally hurt both of you financially for years. Coming up in this video, I'm going to answer 3 of the biggest questions married people have when they start thinking about bankruptcy. First, whether you're legally allowed to file bankruptcy without your spouse, because a lot of people assume you can't, and that's simply not true. Second, what actually happens to your spouse if only one of you files? Does it hurt their credit? Can creditors still come after them? And are they protected in some situations? And third, how to know whether filing alone or filing together is actually the smarter move for your specific situation. Because just because you can file alone doesn't always mean you should. By the end of this video, you'll understand how to think about bankruptcy as a strategy to protect your entire household, not just eliminate debt. Let me be clear up front. Marriage does not automatically mean that you both have to file bankruptcy. Bankruptcy looks at legal responsibility for debt, not marital status. One of the biggest misconceptions I see with married couples is the idea that once you're married, everything becomes legally combined, especially debt. But that's not actually how bankruptcy works. It doesn't look at whether you're married. It looks at who is legally responsible for the debt. And here's something a lot of people don't realize. Marriage doesn't create a joint credit report. You and your spouse always have separate credit histories and credit scores. Now, you can both be legally responsible for the same debt in some situations, but your credit files themselves never merge just because you got married. And this is where it becomes really important. Because in many situations, one spouse can file bankruptcy and get relief, while the other spouse's credit stays intact. And for a lot of people, that's a huge relief, because they're not just trying to fix a debt problem. They're trying to protect their household. That said, just because you can file without your spouse doesn't automatically mean that you should. The issue becomes whether debt is joint or individual, because joint versus individual liability determines risk. Creditors may still pursue a non-filing spouse on joint debts. Filing alone makes sense when most or all of the debt is in one spouse's name. If your debt is out of hand, but your spouse's isn't, and payment is affordable without having to address yours, then filing alone is usually best. It can only make sense when one spouse needs to preserve credit for future borrowing. Sometimes the household benefits from maintaining one strong credit profile. On the other hand, joint filing may make more sense when there are large amounts of joint debt, or when both spouses are individually overwhelmed with their own personal debt, where it isn't joint. If only one of you files, you both would still be saddled with the debt of the other. In addition, there are also household liability exposure situations, including medical debt, that can push towards joint filing. In making this decision, there are 3 things you must analyze. First, who is legally responsible for each debt? Second, which chapter you're considering, straight bankruptcy under Chapter 7 versus a Chapter 13 repayment plan, and how that affects the household. And third, what you're trying to protect. That could be credit profile, home ownership, future borrowing power, overall financial stability. Should you need help answering these questions, I would highly recommend consulting with a bankruptcy attorney in your area. If you live in Burlington, Camden, Gloucester, Salem, or Cumberland County, New Jersey, I may be able to help. If you want to talk about your specific situation, just click the link in the description and schedule a call. That way we can look at your debts, your goals, and your household situation and help you figure out the smartest path forward.